Yeah, please. Lordship, I beg to mention item number 12, hearing matter, my lord. I am for the respondent, Lordship. I have taken consent from the appellant, Lordship.
12.
12, Lordship. Because, my lord, Mr. Esbert has some difficulty, Lordship.
Loudly, please.
My lord, item number 12, my lord. I am
Yes.
for the respondent, Lordship.
Yes.
Lordship, I have taken consent from the appellant, Lordship. Today, my lord, Mr. Esbert has some difficulty, my lord. So I pay for password for the day.
Mr. D. Gogoi,
Lordship.
Learning Council for the respondent number 2, 3, and 4 has paid for listing of the appeal. As paid for an adjournment of the appeal. First of all, it is submitted that consent has been taken from the Learning Council for the appellants to make the prayer. Ms. S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, who is in attendance, have submitted the state has now issued the same prayer.
Highly blessed.
In your travel, is adjourned for the day.
Yeah, please, Your Lordship. I beg to mention item number 13, my lord. My lord, kindly adjourn the day, my lord. And we have some difficulty, my lord.
Hmm?
Today we have some difficulty, my lord.
Your name, please.
L. Borua, my lord.
Okay, on the prayer of Ms. L.
Only matter may be taken after.
Hmm?
Matter may be taken after summer vacation, my lord.
Okay. Learned Council for the appellant has paid for listing of the appeal after and in the 4 weeks. Post of this hourly message for.
May I please, Your Lordship, I beg to
Please,
mention
sir.
item number 14.
Yes, after 4 weeks.
Your Lordship, under the instruction of petitioner, the case may be withdrawn, Your Lordship.
Which one?
Item 14, from supplementary list.
It is not on the withdrawal prayer. You wait, we'll take up.
I beg to mention item 4.
Item
Item 4.
4.
Yes. May please Lordship matter may be adjourned for today.
Okay, we
May appearing on
orders column, you wait, please. We'll find out.
Number 70.
Item number?
70. That matter was fixed there.
Ah.
Yesterday. Same yesterday. Can it be taken up any other?
Yes, Mr. Hamid.
There are some personal genuine difficulties.
Hmm?
There are some personal genuine difficulties, so I am not objecting to that.
Okay. Mr. A. Hamid, Learned MI Caspary. For the appellant is present. Mr. R. Kosik, Learned Additional Public Prosecutor. For the respondent state has submitted that he has some personal difficulty today and has sought for listing of a case on another date. So next week then,
Next week, any date. Madam.
next week side. Thursday. Thursday.
My lord, I beg to mention one IA Lordship, IA criminal 550/2024. Conviction is lifetime, my lord. Till today, this I has not been listed.
You make a prayer then, before the history. That an application will be considered.
My lord.
What is the last question? Also, please to direct it to the my friend. That the instruction. Follow this issue. Follow this, kindly come to the next page, second page. The short parawise reply he has given, the SP, I have received from the SP. So the kindly see para number 2. The second page, para number 2. first page is the order of 2016, 7 to 2016. First page, in respect of Amirupur.
First one is,
First one is Amirupur. Amirupur, he is the. He is one of the petitioner in
okay, one by one, this one is, first one is what?
first one is.
Ijazul Hussain. He has,
No, he
he
is
has filed his writ for whom?
para two, kindly see.
So
para
Lordship,
Abdul
Abdul Salam is the concerned person. 18%.
After Salam, kindly take up third page. In my instruction, kindly take up third page for Abdul Salam.
Abdul
There are
Salam,
clear petitioners. WP criminal 20 or 25, Lordship is taking 20, 25. Then kindly see para two, person's name is Abdul Salam. And my instruction, kindly take up page number 3. Third page,
Second page, I think.
third page. No, no, second page is in respect of Amirupur.
No,
The
second
next-
page here it is Abdul Salam.
concerned is the Abdul Salam.
In these papers, it is,
Lot,
second page is
lot,
Abdul Salam.
lot.
Mutat Abdul Salam. That Abdul Salam.
While steps, putting stapler, and this. As judgment is also. In respect of WP criminal 20,
1 minute will.
what?
So Mr. Das,
Lordship,
Otherwise, this petitioner's father,
Yes, Abdul Salam.
You say Abdul Salam,
Salam.
son of Ali Hussein.
Yes, Lordship. Yeah, I have
They
appended.
were, he was working as labor
Yes, Lordship.
within the area of Kotkoti police station,
Yes, Dudu Kalani, Lordship.
West Karbi Anglong.
Yes, Lordship. And so far, my superficial Lordship, the petitioner father Abdul Salam, he has nothing, any allegation. And at the time of the arrest, Lordship, the concerned police should have to inform the such sort of the allegation imposed. So section 47, which is clear defined, Lordship.
He was,
before
there,
arresting Lordship-
according to them, he was picked up by West Bengal, Karbi Anglong,
Karbi Anglong, Lordship.
Karbi Anglong border, superintendent of police, border branch,
Yes, Lordship.
not by superintendent of police, Karbi Anglong. That is one. One fact they are saying.
So Lordship, the section.
One fact they are saying,
Yes, Lordship. Yes,
that is what they are saying.
yes, Lordship.
This is one. And they are projecting that Abdul Salam,
Yes, Lordship.
son of Ali Hussein,
Yes, Lordship.
was declared a foreigner in a FT case
Yes, Lordship.
in 2023, whose address was Lahorijan, Nutun Bosti, Bukajan Police Station, Karbi Anglong,
Yes, Lordship.
right?
Yes, Lordship.
And the order was ex parte. Order of the Foreigners Tribunal was passed ex parte in an ex parte proceeding. That is what they are saying. We do not know Abdul Salam and Abdul Salam, both sons of Ali Hussein,
Ali Hussein, yes.
are one and the same person.
In fact, there
So
is
that
one-
documents I have appended to Annex 2, his 14 Lordship,
One
Yeah.
vital factor is that
NRC, and also voter
These
ID
are,
Lordship.
these are post 2009 document, but FT reference was of 2009.
So concerning Lordship, the
FT reference was 2009.
2009 Lordship.
FT reference. Yes,
The border branch has verified the
So
record.
Lordship,
For verification of records and for uploading his biometrics in foreigners identification portal, it was verified. And then also that as per verification report, he is the person against whom the application was made. Now, because the petitioner has said the petitioner's name is Abdul Salam. But petitioner, actually the person we have detained, he is Abdul Salam. While filing the petition, they said it is Abdul Salam. Same person, name is changed.
and he is in support of that fact, he is annexing some PAN card and all.
Those are
Lordship, NRC
those are
reflecting.
subsequent documents.
Lordship,
Those are subsequent.
Subsequent document. And the foreigners identification portal, in the foreigners identification portal, fingerprints and all are there. I have asked them. They said it is matching. He is the first. He is the first.
Oh,
So I have appended to the Annex 2.
now why then, Mr. Das, you have written in the cause title,
Yes, Lord.
son of Abdul Salam, but alias Abdus Salam. Page 2.
Please. Yes, Lordship. Abdul Salam at the rate of Abdul Salam. So same
Abdus-
person, Lordship.
Same person.
Same person.
Then he has been declared foreigner.
Lordship, I have nothing ever in this regard, Lordship. So-
I have said already, it was in an ex parte proceeding by the foreigners tribunal. Right. If he has been declared as a foreigner by the foreigners tribunal. The only recourse available is to challenge it by way of a writ petition. Otherwise, the natural consequence after a person is declared foreigner by a tribunal, he is to be detained unless he is granted bail by the writ court. Two
So,
consequences. If Abdul Salam and Abdul Salam is one and the same person,
Yes,
right?
yes,
And he has been picked up by Superintendent of Police Border Branch,
Branch.
West Karbi
Karbi
Anglong.
Yes.
On the basis that Abdul Salam has been declared foreigner by an order dated 27/9/2023 by the Foreigners Tribunal Diffu in FT case number 205/2009. Right?
but one thing.
If that is so, no, you can take the plea. Now, two consequences. If he has not challenged this order, ex parte proceeding has attained finality. Only option is for you to challenge it in a writ petition, as you are well aware. Right? And if that court grants bail, you are out. You are out.
Yes.
Otherwise,
See,
once a person is declared, the only consequence is to apprehend him, detain him, and to send him to detention camp. That is what they have done, they are saying.
Yes.
Now you dispute.
So, Lordship, with due respect, Lordship, so I have taken the instruction from my client, Lordship, the petitioners. So he stated, Lordship, so not a single case involved with my father, Lordship. So that's why, Lordship, so the, I don't know what is the veracity, Lordship. I'll take the instruction again, Lordship, that he takes two more, Lordship, if possible, Lordship. Can you pick?
Okay.
He picks two more, Lordship.
Reasonable enough.
If
The
Okay,
second,
this is one.
second piece of.
Sound second. If it is ex parte notice was not served, then you can challenge it
Yes, Lord. Yes,
before the writ court.
yes, Lord.
And you may, that may be set aside.
Yes.
May be set aside if notice is not duly served. And you will be allowed to participate in the proceeding
Yes.
afresh. That is one option.
Yes.
Right?
Yes, Lord.
And the person is in the appear detention
And if
camp.
you take the plea that Abdul Salam and Abdul Salam is not one and the same person, we will direct investigation.
Yes, Lord. Yes, Lordship. Yes, Lord.
That is one.
I'll think.
Okay, what is the other one?
Other one is Rashid Uddin.
Who is the
petitioner.
person allegedly detained?
Ang-
Rasiduddin
Amiruddin.
is the petitioner.
Amir,
Hamid Uddin is the victim.
Para two, madam.
He is uncle, okay, nephew of Amiruddin. Amiruddin is son of
Here they have said Lalu Mia.
Lalu Mian.
Lalu.
As per our record, son of late Noor Islam.
What is the proceeding against him?
On the
Noor
first
Islam.
page, this is also expert. First,
Lordship,
Oh, ex parte.
this is also expert.
Lordship, his father name is Johar Uddin Lordship. Some different Lordship, different person.
Lalu Mia.
Lalu, I'm sorry.
Hmm?
Lalu Mia is son Lordship.
Amiruddin.
Amiruddin at the rate of Muhammad.
What is the
Second page,
the?
the instruction.
We'll see.
First page is
Oh,
the
just a
expert.
minute. Amiruddin Lalu. Which means.
So Lordship, I have appended the annexer to NRC.
Let me read it.
Page 14 Lordship is NRC documents. Lalu Mia is a father Lordship. Muhammad Amiruddin. With due respect, Lordship, Annexer 1 is a voter ID card, Lordship.
Or annexer?
Annexer 1, Lordship, page 13.
These are not citizenship document perhaps, as per the division bench judgment.
This was in 2017.
This one is 17. You were declared foreigner, this man, Amiruddin, son of Nur Islam. I don't know.
Yes,
But he was declared foreigner in 2016.
60,
And-
7 to 2016.
And Lordship, NRC documents I've appended is a page 14, Lordship.
NRC, what?
Page 14,
Supreme
Lordship.
Court has clarified what? NRC.
Annexer 2, Lordship. Can be find, Lordship, page 14.
RBM.
The father name are fully different. Original page is 15, Lordship.
Page 13.
It's a voter ID and page 14 is the NRC.
Let us assume it to be true, your projection. Amir Uddin, son of Lalumia. In the year 2017, you were 18 years of age. Right? Then let us turn it to 14. It is this NRC published in which year?
18,
18 or 19?
18, Lordship.
18. In the year 18, at the age of 19 years, you have a wife and 4 children. Right? From the document I am saying, your Amiruddin, not their Amiruddin. And what is this? Page 17. Oh, this is his document. So your man was 18 or 19 in 2018,
18, Lordship.
right?
Yes.
And you have wife and 4 children. And this man,
But name has not been matched, Lordship.
not matched.
In the repetition, they said he is 38 years.
Huh?
In repetition, there are 2.
Then, sir,
He says he is 30, the
let us see the cause title.
Amiruddin is 38 years. Para
Where is it?
para
Para?
two- para two of the repetition.
Para 2. Para 2, 38 years. Then how come this document at page 13, you are 18 years in 2017 means you add 5 more years, 17 plus 8, 25. Sir, as per your page 13 document, this was issued in 17.
Yes, Lordship.
At that time, you were 18 years. So you, 2017 to 2025, you add 8 years. You become 25 years today. This Amiruddin,
I mean,
son of Lalumia, right?
yes,
Paragraph 2. He has gained 13 more years. From 25, he has become 38. which one is correct?
Your Lordship,
No, it is your duty to clarify, not to waste time.
Lordship, it might be Lordship the clerical mistake.
I don't know. You have to clarify. Everything cannot be said. It is on oath. It is on oath.
Yes,
Then whatever discrepancy, all are clerical mistake.
so Lordship,
Because I am surprised that by 25 years you have, sorry, page 14, this NRC was published draft 2018 or 19. So if we go by the PAN card, you were about 19 years of age. At 19 years of age, you have your wife and 4 children. Minara Begum, Sirajuddin, Firozuddin, Jasmine Begum. 4 children. So you might have married at about 10 years, perhaps. 10, 11, 12 years. These are to be explained, sir.
yes.
If you don't clarify these things,
Lordship,
it is very difficult to espouse the right of personal liberty.
yes, Lordship.
And they are coming up with a view that you are the person who has been declared foreigner as far back as in the year 2016. All these documents are subsequent, definitely.
Somewhat contrary to Lordship, the fixed matter by 2 more Lordship. I'll take the instruction Lordship in this regard, Lordship.
Because half-baked thing is very
Yes, I
difficult.
understand, Lordship. I'm sorry for that. So, fixed by 2 more Lordship.
Because things are not,
Yes, sir.
dots are not
Yes,
joined.
yes, Lordship. I'm sorry for that.
At
Lordship.
the age of 18 years, you have wife and 4 children. On the other hand, you are saying 38 years. Nothing is adding up.
Yes, Lordship. I'll take the instruction.
One, let's get this clear. But they said that they were detained on 24/4/20. In fact, they were apprehended on 24/5/20. After that, they are in detention. Possibly this date is not correct. 24/5. They have said 24/4.
No, 24/5, the clerical mistake. Lordship.
Notwithstanding the illegal detention, legal or illegal detention of the persons, both the petitioners are liable to be visited with heavy cost. So-called son and so-called nephew.
Lordship, so hearing
Things
Lordship,
are, from the writ petition, things are not adding up.
kindly fix my-
We have taken up this matter expeditiously. Monday, then today. He has been asked to obtain instructions. He has obtained instructions. Though initially verbally on Monday, but he has got a responsible or at least officer. Superintendent of Police has made this statement, at least document before the court,
So kindly fix-
and things are not adding up.
so, Lordship, kindly fixed on Monday, Lordship.
To come up with, you are invoking a serious jurisdiction.
Yes, I understand.
We have taken up with serious, all seriousness,
Yes, Lordship.
but things
There's
are
a-
not adding up. With
Lordship,
this minimum documents, which are also doubtful.
So Lordship, kindly fixed on Monday, Lordship.
Tomorrow, if you don't add up,
Yes,
it is up
yes,
to you.
yes, Lordship.
Both this so-called projected son and projected
Yes,
nephew. Not to speak about the person who detained. We are concerned with them. But these petitioners, their credentials are doubtful. If he has, I don't know the why he has not detained. It is up
Yes,
to you. We thought that it is matter of serious.
I understand.
concern.
Master, Lordship.
Okay, on the prayer of Mr. R. C. Das, and counsel for the petition, is the case to follow, same thing. Mr. Nath, you try to obtain further instruction.
Master,
What this business about Amiruddin? Verification কৰিব লাগে যদি কি হৈছে Yes, yes.
So jail appeal মাইল
Heard Miss M. Borma, learned
legally.
for the appellate. And MS SH Bora, learned additional public prosecutor for the respondent number 1, State of Assam. This criminal appeal under section 415. 2, BNSS legal is preferred against a judgment and order dated 27/11/2020 passed by the Court of Learned Additional Session Judge cum Special Judge within bracket POXO Tinsukia bracket of special in POXO case number 108 within bracket M of 2022, arising out of Digboi Police Station case number 33 of 2022. By the judgment and order dated 27/11/2024, the appellant has been convicted for the offense under section 376(1), Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000, which default stipulation. Also, we have gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of POXO case number 108 of 2022 are to be called for. Issue notice returnable in 4 weeks. As Ms. Bora, the traditional public prosecutor, has appeared and accepted notice on behalf of the number 1 State of Assam. Issuance of formal notice to the said respondents is dispensed with. Para. The appellant shall take steps for service of notice upon the respondent number 2 stroke informant in terms of the practice direction is so and so. Para. The learned additional public prosecutor is to obtain a report as regards service of notice upon the respondent number 2 best informant from the officer in charge, Digboi Police Station, by the next date of listing.
E61 perhaps notice may not go as per notification
Okay, then register post AD.
of like.
Or legal aid counsel has been appointed. Paperwork ready?
Yes.
File to sub, paperwork asan. Karna hai. Okay. Heard Miss
P.T. Gupta. P. Gupta.
P. Gupta. Learned counsel on behalf of Mr. Ayaz Dotto. Learned legal aid counsel for the appellant. Miss S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam. And Miss A. Gogoi, learned legal aid counsel for the respondent number 2, also. As The paperwork is ready and all the parties are represented, office to release the case for hearing due course. A copy of the paperwork is to be supplied to Mr. A. Gogoi, the legal aid counsel for the as per number 2 within a week from today.
May I please, Your Lordship? Here in this case, also the appellant has claimed for to be juvenile on the date of occurrence, Lordship. And accordingly, a report was called by this honorable court, and as per my instruction, Lordship, that report has been received, Lordship.
It's received. As no document is available, authentication based was done.
You represent the appellant.
Lordship.
Does he have any, has he gone to school for the private respondent also?
Yes, notice was served.
Miss B.
showing
Borman,
that.
B. Borman, B. Borman, put a quick लिखे. M. Borman side, the B. Borman. Okay, B. Borman is there,
B. Borman.
huh?
Legal agent.
Everywhere is B. Borman. Who is B. Borman?
Maybe somebody is HRE and B Borman.
It is a, it's a Hyder Ali.
Okay.
Again, and the person, they have engaged, engaged.
Okay, engaged
counsel. Engaged counsel. On last occasion, they appeared.
Then when Miss B. Bhuyal has senior counsel and additional public proceeding. For the respondent who will take up this. No, this is because the district judge has to make the order based on the possibility. I'm giving you, what is the proper procedure, I also don't know. To be frank enough, since he's saying that the district judge order is to be there, has to be there, he simply forwarded the report. It is the juvenile who has to come before
Yes.
that court. He has to be brought before that court.
Yes.
After taking the report into consideration, he has to pass an order.
Yes, yes, that has to be
That
there.
is not
That has to
there.
be there. In that case, Lordship, instead of giving the copies to us, may I pay for directing the Senate
Yeah,
session?
that is why I have,
Be done.
the
That may be
proper
done.
procedure,
Yes,
I
that order,
I
that
have
order
said
has to be
frankly,
there. That order has to be there.
I am candid enough.
Lord,
How to go about,
Lord.
I don't know.
As per my knowledge also that,
That,
that
but
has.
Yes.
we should, at least we should give the signal that it should be the proper procedure.
Let it be sent back.
To send back, I don't know, but with what kind of observation I have to send back? Send back is easily done. Everybody can, okay, I'm sending back. And it, after 3 months, it again comes back. With lacunas. What will happen to the appellant? If he really a juvenile,
My lord,
please throw some light
it's not shipped.
how to do it.
That Lordship may fix on Tuesday.
Procedure, then I'll observe that this should be done
Lordship.
by the learned session judge. And you send the, your observation, whatever is possible.
In that
Please.
case, Lordship may. Yeah, please.
Idiot. Yeah. প্রথমটো একটু order করবার আছে। কারণ to the seeker নিচে restriction.
Lordship may kindly say order dated 8/4/25 passed by this honorable court, Lordship. There was specific direction to make inquiry and submit a report. That report probably will be, that order will be probably treated as report. So inquiry was done.
Because somebody from the medical board statement is to be made to prove the medical report. I think this is the proper procedure. His statement is
Experts, your lordship.
the
Like,
expert.
yes.
And thereafter, it is to be, he has to opine that, yes, otherwise,
And
it is a, Mr. Amit,
Postmortem examination report is a previous statement.
Yeah.
It has to be testified
by the.
by the doctor. Similar, if you go by the similar manner, this is a previous statement. It has to be exhibited and proved,
Lord. It is
to
there
my
in-
little understanding.
It is there, can we get that report, Lordship? That documents which you have forwarded, Lordship.
You have a look. There is nothing.
Lordship.
One line. One thing, one line, and the other is handwritten.
Lordship.
Have a look.
Lordship. Avlai.
And the order of the special court also.
Paperwork is there.
One minute, Mr. Lutfi.
Yes.
Maybe. The appeal is already admitted, my lord, but it has come for consideration of IMA, for suspension of sentence. There was a judgment of 12/10/2023, my lord. There are altogether there were 4 accused persons, my lord, and all 3 were acquitted, and only one, my lord, correct, Ram Mandal, my lord. They were convicted on 341, 323, and 302 IPC.
How many face trial?
4, my lord.
4.
3 were acquitted, my lord, and 341, and this accused appellant, my lord, he has been solely convicted. 13 witnesses were examined, my lord.
340.
There were eyewitnesses to the occurrence, my lord, PW1, PW2,
341, 323, 302.
302. And there are eyewitnesses,
302
my
is
lord,
live. Others were acquitted.
acquitted. Now, question is, my lord, what you can do, there were eyewitnesses to the occurrence, my lord. The PW1, PW2, PW3, and PW4, PW5. In a statement before the police, my lord, there was an omnibus statement implicating all the accused persons. But during trial, he has implicated only this. In trial, my lord, he has implicated only this appellant. That is the question. This question of appreciation. only.
Then 302. If it is a case of appropriation, appreciation,
Appreciation, whether that's quoted, because in the 161 statement, he has implicated all the.
maybe, but whether you have
That,
brought all this.
Your statement is there, my lord. That has come. That has
No,
come.
no, you have to bring in
Yes, yeah, I understand.
by way of legal method.
Yes, that legal matter principle that has been followed, my lord. Naturally, my lord, that.
No, 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 we don't appreciate it.
I understand, but that is the.
We appreciate only Tehsildar.
That's, I understand.
Huh.
But that has not.
We
been
don't know the method. We don't recognize that method. As simple as that.
Understand, my lord, but.
We cannot appreciate that in view of Tehsildar, right? So if more appreciation is required, then I think it would be
Because you also can also go to the case there, you have necessary.
not case diary.
I
I cannot go. I cannot make use.
Yes, for purpose of 145, your lordship can use it.
No. Where? You have done so already.
That's so, but even then, procedure. is
You
not
have
followed.
exhausted the remedy.
I understand if your lordship holds that procedure that has been not been complied. with.
No, no, no. We
That-
don't know. We don't do that.
That power is also there, my lord.
Last week again, Tehsildar has been followed. Last week.
Your lordship, there are judgments, many, my lord.
No, no. I am saying that Tehsildar has not lost its utility.
No, it is still there.
Only last week also it has been, not last week, just before the meeting office, Justice Oka again
I understand.
reiterated Tehsildar only.
But nowadays, but session judges, they don't, the judges they don't follow what we can do. my lord.
Lawyers are supposed to know.
That is a difficulty, my lord, because we have to,
I cannot lay down that rule.
Because we are supplied with the copy of the 161 in photo state, madam. You'll also see that the applicant,
That,
that hurdles we are facing, madam.
that I cannot say. Everything is laid down.
I understand, madam. The parts which are contradictory, we used to ask the witnesses, have you stated so? You said, I do not, I did not state. Simply said.
Then that is first part of 145.
Yeah, I understand.
Then second part,
Second part, I would able confront it, that yes.
no, then the manner in which
Manner means whether it has to be exhibited or not, that particular state.
you know very well.
Yeah. But
Mr.
the-
Kotoki,
the
you are,
prosecution also
doing,
when-
you are following Tahsildar,
No,
the
no,
other
also-
defense counsel does not follow, that is a different issue.
Normally the courts don't, that is different. Not necessarily they say, man, what, our hands are tied, man.
If it is appreciation 161, we cannot look into. If we have to go by the substantive evidence, and if there is eyewitness, so then it is up to you. We can consider, our paper book is ready.
Yeah, that is.
If it is a case of 302, okay, 30, if it is not 302, 304,
That is a different issue, madam. But
That is
now it is a
different.
question of appreciation of evidence.
Oh.
Because in the statement before police, he has implicated all of the omnibus statement is there. But in so far as in trial is concerned, in the substantive evidence that he is implicated this present issue. There are eyewitnesses to be occurred, my lord. And
oh, only because of a cow damaging Kothia.
yeah,
Yes, what to do? Oh, to hear or consider this?
but actually, my lord, I'm handicapped because actually it was this first case as well. Your lordship fix a date, another date, my lord, will
To hear the appeal?
appeal, yes.
2003.
Because it's matter of 23, my lord, already 2 years gone.
2 years gone. Contradiction or eyewitnesses? Hmm? Oh, injured eyewitness.
Injured.
Both. Then we'll hear the appeal then.
Yes, yes, that is a question of appreciation, my lord. Because one of the accused also expired, my lord. There was there. Is that
But Mr. B. Kotoki, learning counsel for the appellant. And Ms. B. Briel and additional property consistent, so. But as one state. So. Not in June and in the. Particulars again. Particulars again. Okay, in the next hearing list then.
Yes.
Because from the hearing list.
I understand, madam. Then normally the procedure is.
As agreed to and support by the learning council for the project, list the case, in the hearing list, commencing from 14th of June. Orera.
Section 4 Oxnard.
Section 4 box. LCR.
Informant party is there.
All are present,
Yes, ma'am.
all objections filed.
Yes, ma'am.
Misconduct legally counsel.
Would not yet.
So clarification given.
Heard Mr.
Yes,
A.R. Tom.
Ajay Ghosh, no, Ajay Ghosh.
A.J. Ghosh, Land Council for the appellant. And Ms. B. Bhuya, or as such, Bora, and additional public prosecutor, the respondent number one, must state of Assam. Post of S. For
Like that.
This was dated 23/05. Services.
from the case papers, from the report received from the, as per report of the officer in charge, Imolaguri Police Station, the notice upon the respondent number two, that's informant has been duly served. As none has appeared, duly served or duly served on. Because it has been duly served in January 2025. As none has appeared, to represent the respondent number two, that's informant, we deem it proper, in the interest of justice, to appoint. No. Okay. Mr. Ujjwal Chaudhary, Land Council from the panel of Legal Aid Council, to represent the respondent number two, there's informant. First, as the records from the from the trial court, I mean received from our office to prepare the paper was published the case after courts for report as regards readiness of the paper.
So the legal aid counsel's name may be so.
And the name of the name of Mr. Ujjwal Chaudhary, Land Legal Aid Council. So the respondent number two, be reflected in the respondent side in the columns. Is to be reflected. Is to be reflected.
May I please your lordship?
Hmm.
My lord, in this criminal appeal, there is a delay, my lord, 54 days, my lord.
Yes. How much delay?
54 days, my lord.
54 days.
Exactly.
Yes. Notice is served.
The delay is explained, my lord, in paragraph
Part-
number 5,
Paragraph number 5.
page number 5.
Heard Miss B.R.A. Sultana Land Legal Aid Council for the applicant appellant, and Miss M.S.H. Bora, Land Additional Public Prosecutor for the opposite party, that's respondent number one, state of Assam. Full stop. The notice as per order dated 27/5/2025 of the Lojima Court, the notice upon the respondent opposite party, the respondent number two is complete. Post of none, respect service of notice, none has appeared. Till date for the respondent opposite party is number two. Informally. Post of. The instant application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 54 days in filing the accompanying criminal appeal under section 415, BNSS ticket for 2023. Also, the accompanying criminal appeal is preferred against a judgment, an order dated 39/2024, passed by the Court of Planning Special Judge Jorhat in special case number 34 of 2023. Postal. By the judgment and order dated 39/2024, the Land Special Court has convicted the applicant, appellant, for the offense under section 376 within bracket 3, Indian Penal Code, as well as under section 6 within bracket 1, POCSO Act 2012. First of in view of section 42 POCSO Act, the applicant has been sentenced to undergo
20 years. Rigorous imprisonment of 20 years.
rigorous imprisonment for 20 years
With fine of
and to pay a fine of rupees 10,000, with default stipulation under section 376 within bracket 3 IPC. Convicted under section 4 or 6?
6 Lord.
6.
6-1.
6 within bracket.
Oh, no, 4. 4 and 376, page 41. Six or 4, huh? Para 60. So we have gone through the statements and amendments made in this application, more particularly, which paragraph? No, nothing.
64.
Paragraph 5, nothing. Absolutely nothing. So that's why it's more particular. It transpires that the judgment and order, after passing of the judgment and order of conviction and sentence on 39/2024, the case papers were forwarded from the authorities in the Central Jail, Jorhat, in November 2024. And thereafter, the High Court, Guwahati High Court Legal Service Committee had appointed the Legal Aid Council on 17/12/2024. Post up. Having gone through materials of record, we are of the considered view that the applicant appellant has been able to make out a case, privacy case for consideration or for showing sufficient cause for condoning the delay of 54 days in preparing the accompanying criminal appeal. First of Miss Boral and additional police prosecutor dispense to dispense no. That's one number 2. Again, at the stage of hearing, we'll go to the I want to repeat for you. On
Most of this.
May I please, your lordship? Lordship, this is an application.
Agreed by lesser sentence.
Lordship,
We have to issue notice at this stage.
lordship, it's for condonation.
We have to issue notice.
Yes.
Heard Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India. For the applicant. Full stop. The instant application under section 5 of the Limitation Act 1963. Read with section 20, read with the proviso to section 25, 21 within bracket 5 of the National Investigation Agency Act 2008 is preferred, seeking condonation of delay of 51 days in preparing the accompanying criminal appeal against inadequacy of sentence.
Lordship,
Okay. So stop. Passed against the opposite parties, provided by the learned Special Court Nia Assam, provide order dated 30/01/2025. Issue notice returnable in 4 weeks. The applicant shall take steps for service of notice upon the opposite parties by registered post AD within 3 working days.
lordship may perhaps mention the special case number,
Oh, special case number.
special NIA case number 3 of 23.
Liquidable. Special. Nia NI case number 03/2023.
So, my lordship.
Yes, you made a prayer in
Yes,
the
sir.
morning.
Withdraw the matter, Your Honor. Withdraw the
Huh?
case.
Withdraw the matter.
Yes, sir.
It withdraws whatever it is. Mr.
A. Rahman.
A.R. Rahman,
A.
A. Rahman, learned counsel for the applicant, has submitted that the applicants who wants to withdraw the instant application as well as the connected appeal. Now, preferred under section 28 of the Hindu Marriage Act, 1955. Post. In view of the above submission made by Mr. Rahman, the instant application is dismissed on withdrawal. Post. Main to leave. In view of the order passed today in the connected interlocutory application, IC number 3770/2023. The instant appeal stands dismissed on withdrawal.
For a consideration of IA, my lord.
IA,
Yes, ma'am. 216 of 2025, ma'am.
1 minute. Who are the applicants?
Applicant, my lord, Sahabuddin Ahmed
Sahabuddin
and
and
Rakibuddin.
Rakibuddin.
There were three persons were convicted, my lord. One is Sanjeev Pal and
In
other
the
two appellants.
paperwork, where is that sentence part?
Sentence, my lord, he was sentenced to undergo rigorous imprisonment for life under 302 and 10 years for 201.
1 minute, 1 minute. Which part, page, in the paperwork,
No, Popeye.
sentence part?
Lordship, just now, Mr. Kubo
Huh?
from our office.
They have already filed objection, my lord.
File of this.
In the
1 minute, miss. If
When your lordship takes up paperwork, then will come under section. Page 217. Yes, ma'am. That conviction part is there, ma'am. In case accused person A1, A2, 3 were found guilty under 302, 301, 34 IPC. It's a 52 paragraph. Could you enter?
Madam, I had just flipped through the prosecution evidence just now. It could be, the appeal could be disposed of, perhaps.
Lack of evidence.
Looks like. We can take up the appeal itself.
Some other,
Your lordship, accept a statement before policeman. ma'am.
So, I had just flipped through.
Yes.
It
Accept
looked
the-
like.
some other day for final hearing.
Accept statement. IO is the one. He is the only evidence. ma'am.
IO is only.
PW 21.
I have gone through I had just flipped through.
Yes, ma'am.
Does not look like, though the paper book is very heavy,
No material.
One thing that
it is the
judgment,
other way around.
in the judgment, he has reproduced every witness.
What is 134? It is the quality of evidence, not the quantity. So quantity looks like heavy, but quality may not be the same.
Absolutely no evidence. Why IO may be disposed of by law, your lordship may grant them bail.
No, we can hear the appeal.
Because
but
they- no,
why
one
the
thing-
Other man.
The other man, that is the difficulty. We don't know whether he is filing appeal or not. That's why let him
It's
go on bail,
okay,
my lord.
It's okay. You can hear the appeal. You are not concerned with him.
Yeah, I understand, my lord. We may not know whether he is filing appeal. They may
A
later.
non-appealing appellant, it is up to him.
Yes, my lord.
Yes. Let it
Some
be
other
done.
day.
We can let him grant bail, my lord. Your lordship may grant bail, my lord. Let,
Yes. If you are ready, we can take up.
Lordship, entire matter be disposed of, not today, on Monday.
Okay.
if your lordship take up PW 21, matter will be clear, man.
Okay, let us read for her benefit also, for our benefit.
Yes,
also.
man.
He is the material witness only.
Only material.
Okay. On the, we'll take up the entire appeal.
Entire
Then
appeal. Then
it is
your
better.
lordship. Just,
Just, we'll have a reading.
but one thing is that in judgment, your lordship, all the statement of all the witness has been reproduced. As it is. That's why it has become so thick.
Okay.
man. If your lordship goes to the judgment also, everything is there, clear, man.
No, I will read the material witness.
Yes. So if you take up PW 1, my lord, then your lordship will also, from
PW1.
PW 1 also is not, he
There is
doesn't,
nothing,
nothing.
nothing. I have just flipped through. PW2, nothing.
Then PW 21.
PW3, no.
PW
Which is the longer evidence? Okay, medical is, death is homicidal,
Not homicide, man.
not homicidal.
Not only because it was decomposed body.
Okay, okay. We'll look into it, but what is the material? PW2, 20?
20.
Okay,
20 to 21.
okay.
Page 651.
Page?
51.
PW21,
Yes, ma'am.
okay.
He was the investigating officer. On 29/8/2008, I was posted as the attached officer of Sonali PS on that day. At 7, one person, namely Haren Tanti, resident of Haidapuri, submitted an application stating that one female dead body was found in the drain of Haidapuri TSN. On receiving the application, also Sonali PS registered a case, UD case number so and so. Accordingly, I was entrusted to investigate the case. After taking the investigation, I went to the place of occurrence, found a dead body in a drain. Lower part of the dead was in a decomposed state. I conducted an inquest of the dead body in presence of executing magistrate and witnesses, and where I put my signature. I saw a tattoo mark, Sri Krishna in right hand. So this is, I saw a tattoo mark, Sanjeev in the left hand. I forwarded the dead body for postmortem examination. I drew up the sketch map of the place of occurrence. I recorded statement of witnesses Exhibit P3 is the inquest report. And Exhibit P6 is the sketch map, the place of occurrence with Sonari PS UD number so and so. On 4/9/2008, one Azhar was lodged by Anantok Gwala, son of the deceased Junaki Gwala. He also submitted a photo of his mother, Junaki Gwala. On receipt of the Azhar, OC of Sonari Police registered a case number being Sonari PSK case number 194 of 2008 and trusted me to investigate the case. I recorded a statement of informant in the police station. I seized one color photograph of the deceased Junaki Gwala, which was submitted by the informant. I showed some photographs of the deceased to the informant, which I have taken during the conducting the inquest. Informant identified the deceased of the photograph as his mother. Exhibit 7 is a serial list by which photograph of deceased Junaki was seized. So and so in my signature. Material object number 1 is a color photograph of Junaki Gwala, which I have seen today. I recorded a statement of Chittaranjan Dasgupta.
PW, Chittaranjan is PW?
No, he's expired man.
Oh, he is not there.
No, not there. Man.
Okay.
Yeah, I recorded a statement of Chittaranjan Dasgupta when he stated they saw the deceased Junaki came out from her house along with the accused Sonjipal. He also stated prior to that, Junaki told Chittaranjan that Sonjipal was giving promise to marry her, committed sexual intercourse, and the pregnancy of Junaki got aborted by Sonjipal many times. Once again, when she became pregnant, Sonjipal denied to marry her, told her to do something for her. Sonjip also threatened. After taking the statement of Chittaranjan Dasgupta, I forwarded him to court for recording his statement before the magistrate. Exhibit so and so is a 160 statement of Chittaranjan Dasgupta. Thereafter, I went to the house of the accused Junaki Gwala and prepared a sketch map of the place of occurrence and recorded a statement of some witnesses. Exhibit 9 is a sketch map of the house of the complainant and the deceased. So and so. After interrogating the witnesses, I found the deceased walked Junaki in the house of Sonjipal, and Sonjipal is the involved in incident. So I went to the house of Sonjipal, could not find him. On 5/9/2008, I got information Sonjipal was present in the house. Accordingly, I went to the house of Sonjipal, apprehended him and interrogated him. In the statement of accused Sonjipal, he stated that then he states about the statement before the policeman. Whether I should read, it is not necessary, man. It can be skip over because that is a part of investigation, man. There he says that
Any discovery?
discovery is one plastic rope, man.
Okay, which part?
That last part, my lord. Then page 54, second paragraph. When they reach Junaki, Sonjipal tied a plastic rope with the neck of Junaki, Gwala and the persons hold her, just so and so. All accused persons pulled the rope which was in the neck of Junaki and killed her. Thereafter, threw the plastic rope with Joboka tea. After that, they took body to Junaki to Hydropaturi and threw the dead body. I seized one plastic bag which was sold by accused Sonjipal.
Pull the rope.
Then later I went to the place of occurrence, do a sketch map where Junaki was killed at Joboka, Bagan Sariel. Exhibit P10 is the sketch map. Then on 6/9/2000, I along with accused Sanjipal went to house of Sahabuddin. In his house, could not find him. Again on 2 p.m. went to house of Haiki Ahmed, Hakimuddin to his house. On finding in his house, I apprehended him, brought to the police station. I communicated to Simuliguri police station and Simuliguri police station apprehended Sahabuddin and handed over to us. We took June and Sahabuddin in our custody. I seized one scooter along with the relevant documents as shown by Sahabuddin, which was used at the time of incident. I seized one vehicle, Tata S, along with relevant documents produced from Tultul Borua, which was used at the time of incident. Exhibit P3 is the seizure list by Tata so and so. Exhibit P4 is a seizure list. On sufficient materials against the accused person, I arrested the accused person, forwarded him to the court. Exhibit P12 is just arrest and forwarding report of accused Sonjipal. Then case arrest memo, forwarding report. Then he said, I sent a viscera of deceased Junaki Pal. Later on, I collected the postmortem report. Exhibit P16 is the postmortem. After going through the statement of witnesses, I found sufficient materials against the accused person. Accordingly, I submitted charge sheet. Now there are some, what happened? There are some press persons were examined. These press people, my reporters, were present in the police station. And they heard by lot, they are making confession. Man. That is the inadmissible.
Yes.
There is no evidence.
You can hear it.
Something?
Okay, Mante. Last scene together.
That's not with me, man.
No.
With Sonjipal.
Ah,
No, I'm not Sonjipal.
no, as a whole.
Oh, yeah. Because on the basis of Sonbia's statement, we are implicated. Otherwise, there is no other statement.
No arrested.
No other statement.
That is 161 only.
Only one statement. That is statement before police.
Yes, Ms. Mia, you can take up.
Monday?
On the hearing list.
The Gavai judgment recently has come on because circumstances evidence, my lord. Like earlier judgment also, but that also we can place. Chain of circumstances required.
Heard Mr. P. Kotokil and counsel for the appellants. And Ms. B. Vriel and senior counsel and initial public prosecutor for the respondent state. First up, after hearing first, the land counsel for the parties for some time, we, it is. Score is of the view that the appeal, since the paperwork is ready, the appeal itself can be considered on merits. First, raise the case on Monday. So it is observed that in the event the appeal is cannot be considered on merits, the interlocutory application, the application IS number IC criminal number so and so will be given consideration. If this can be done,
Yes, ma'am.
that is automatically done. You have received a paperwork, Miss? Okay. Yes, madam.
Lordship, as per official dated 13/5/2025, your lordship, no response was filed by the
But if
respondent, your lordship.
No response has yet been received from the sole respondent. Notice itself has not been served.
Lordship, can you allow me to take quick step, lordship?
Okay, Miss
J. Bora, lordship.
J. Boral Land Council
Lordship,
for
can
the
it,
appellant.
lordship, can it be, dusty service may be given, lordship?
Is present. Peruse the office notes dated 26/3/2025 and 13/5/2025. First of, Ms. Bora, Land Council for the applicant has submitted that the applicant may be allowed to take 3 steps for service of notice upon the opposite party by registered posts. Questions? Postal. As prayed for, the applicant is allowed to take 3 steps for service of notice at the correct and proper and correct address of the applicant by registered post with AD within 2 working days from today. Post of. In addition, as prayed for, the applicant is also allowed to take steps for service of notice upon the opposite party by way of justice routed through the registration and so comprehensively. Is the case of
Lordship,
3 weeks, 4 weeks, 4 weeks. Is the-
there is a minor mistake done by me, lordship. The pin code was wrong, lordship.
I have said correct and proper address.
Lordship and lordship.
Otherwise,
Yes,
amendment
lordship.
application.
I am open, sir, lordship.
Megha Timum. Megha Timum. Three zero two.
Sentences for life imprisonment, 10,000 fine.
How is the judgment?
Judgment at page, my lord, 26,
20.
relevant, my lord, paragraph 44, page 39.
Yes, 20 paragraph.
44, page 39.
P. Um, 302,
direct evidence or circumstantial?
Confession.
Confession, circumstantial,
He has
not a
confessed.
direct
Confession.
evidence, not a case of direct evidence. Circumstantial evidence. And what are the circumstances?
That he has.
Confession.
Confession. He has himself admitted
Confession means what? 164 or extrajudicial
before the judicial.
Huh?
Before the judicial
before the judicial?
officer. He has confessed. There is a confessional statement.
Confessional state.
But he retracted the, AB's 313.
Retracted. So retracted judicial confession. Yeah, minor judicial confession. Reflection time but addition. Only 3 hours reflection time.
3 hours.
Same day.
Same day.
Where is the exhibit?
Exhibit 6, my lord.
Exhibit
6. Page
Page.
55.
It was recorded when?
It was recorded on 19/9/1994. The incident 19/9/1994. Page 69.
Oh, when executive magistrate.
It was in Kabi Anglong. Then
So
judicial was
executive magistrate. Is 50. Where is the medical report?
page 43.
Right. Please.
When he was arrested?
On the next day of the incident.
On
On the-
19/9 or
On 17/9. 16/9.
I.
PW 5, madam. Page 15, 15.
Clear to some.
The victim died on the next day, around 12:30. During the trial, he was most of the time on bail, my lord. At the time of conviction, he had undergone only 1 year, 1 month, 20 days.
Produce quite a lot of further. People, when I people, 6 plus 1984. Working. When I come. 6 plus. 79. Boundary complaint about person injured. Or we took. Is there? Statement.
On 79, he was arrested, and 3/1/95, he was released on bail.
No, when
No,
he was taken forwarding to Sapna. It to. It's 89. 89. You can say. 89. 89 তে মানুহ মৰিছে। 89 এটা player দিছে to add 302. Right. That's the forwarding report. 79. Again, never any. So 79 তে Superintendent District Jail had the honor to forward have the dead body of the following. Okay, civil hospital, sorry. So he was taken into custody, forwarded to the court. And night of so friends. Sufficient. Sufficient statement be recorded. To listen, 18-9. 18-9. 18-9 report to the direction.
there is an order in page 54 of the paper book, my lord, on 19/9/94.
Page.
Page 54 of the paper book.
54. Okay.
That the IO placed to record the confessional statement of the accused. Sri so-and-so would record his confessional statement. And on the same day, after 3 hours.
Find out that order in the case record. If he is from police custody, directly, things are different.
with 3 hours reflection time. It might suffer. To 89. 89, একটু মারি সময়, হ্যাঁ? একটু following it, the corporation statement and we will record. 18 to 18 লেগেছে। নয়, একটু তার according to 18 লিখেছে prayer to add section 311 18. Section 3 can be added. It's the proceedings to to postman. To proceeding, it equal legal before, again, to 79. Auto program, auto opening high to make that. When it plans, we should 8,000. Yeah, পুলিশ করলে এটি নেই, এটা যে 79 হবে। Production is 18. Direct police president. কিন্তু রেকর্ড কেটে গেল না, এটা সব কিছু, এটা তো সব কিছু এটা সব কিছু এটা কি মানে পুলিশ কাছে বলতে পুলিশ কাছে বলতে itu order to bisa গেছে order to নাই না itu আপনার এই order to itu সব beginning 19 produced from custody. Find out 18994 order from the case record. He was produced from judicial or police custody.
If your lordship may take up the matter tomorrow, I'll look into the matter. This aspect I have not.
Oh no, this is the veracity of this whether it acceptability of the
Confession is.
confession is to be examined firstly, then other circumstances. There is no eyewitness.
Stated that I have told them. And I was there with the victim. then. Yeah.
Okay, we'll take up tomorrow. Prasad, another question, please, against tomorrow we'll hear this. That one and the other one. Other appeal may not be heard. These two will hear. Once we have looked into it, then no point. Then you see only extrajudicial, sorry, the judicial confession, which is retracted. That is the only basis. One Ural Mari and
One injury. One injury on the side.
one injury. Maybe homicidal, that is a different thing, but whether it can be connected with the accused, that's all.